Gentlelady yields. Chair recognizes the gentlelady from Florida, Ms. Lee.
Thank you, Mr. Chairman, and thank you to our witnesses for joining us today. I think you have a group of members here that are very interested in finding ways to refine and streamline our criminal justice code, and you all are very helpful with the ideas and thoughtful testimony that you have brought with you here today. I would like to go back to something, and Professor Turley, I'm going to start with you. Mr. Fox told a story about a case in his opening remarks that I thought was very instructive in this way. I am a former state court judge, and in my experience, juries work very hard to follow the instructions that are given to them, most juries, and to apply the law correctly as charged by the court. What is the effect if the elements of an offense are incoherent or vague? What is the effect on the instruction that goes to the jury, and how might that affect cases that they are deliberating upon?
Thank you for that question, because it's probably one of the most important ones that the committee can tackle. The effect is huge. I spent most of my career as a criminal defense attorney, and I can say that there are certain crimes that you don't have much of an argument to make because we have strict liability criminal offenses and criminal negligence offenses. I actually testified against both 27 years ago. I think that those are two categories that the Congress should focus on, that we could do away with most of those offenses. Because once you get into court, you don't have much of an option. But so the point is that if you've got a client as a criminal defense attorney who comes on to you on one of these crimes, you've got, if you take a look at the Yates case that went to the Supreme Court of the undersized grouper, right? Those cases, while we look at them and go, my God, how did that ever be criminalized? It's a tough case for a criminal defense attorney because the judge is handcuffed. The judge is going to give instructions based on that statute. And as you say, jurors are very faithful in carrying it forth. And the judge tells them, you've got to apply this. So we have to eliminate those laws. We can't just rely on discretion. And the other thing about prosecutorial discretion, which is enormously important, because I really do agree with Congressman Ott when we talk about the role of prosecutors here. Most prosecutors, like Mr. Tolman, are very faithful and very thoughtful. I've worked with a lot of great ones. But prosecutorial discretion only works if you frame the range of discretion. So what you've done is you've blown away that frame. So there's literally discretion now for prosecutors covers conduct that everyone commits every day. That's the danger. It's not that we're not saying you shouldn't have discretion, but you're the ones who are supposed to wall in the discretion and allow them to work within it.
And staying on that point, I think that gets back to, I believe it was Justice Scalia, the fuzzy laws that we passed and then hand over to regulatory agencies. Share with us, if you will, what the consequence of that is when we leave too much discretion in the hands of the regulatory agencies to actually criminalize behavior, and have you seen disproportionate impact or exercise of that authority by different agencies?
Yes, I mean, there are certain agencies that pull the trigger pretty fast. But the point is that whether you're on the regulatory side or you are an actual prosecutor, there's a tendency to just lower the boom on people, to count stack, because what you want is to get a plea agreement. Most cases end up in pleas. So if you're on the defense side, you're looking at a client with limited funds, and those funds will evaporate the minute they start a criminal defense. And I mean evaporate within months. So they will have to sell their house, they'll have to tap their relatives, and the alternative is the prosecutor says, look, instead of my bringing these 100 counts against you, I'll let you plead out on 2 with no jail time. Most people accept that. And they then become part of the criminal justice system. They get a record. That stigma follows them. They have trouble getting jobs. They have trouble possibly getting leases. It's a horrific system.
And on that subject, Mr. Tolman, I know in your written testimony you mentioned the Safer Supervision Act, which actually discusses the intersection between community safety and successful reintegration.